Over the final session of this conference, and the panel is going to be addressing the issue of defenses to environmental prosecutions from a variety of perspectives. We're going to hear about the classic defense of due diligence and its complexities. Then we're going to hear about many of the other defenses that perhaps we hear less about but are equally important. And then a very interesting final session on Aboriginal rights as defenses to environmental prosecutions. So we have a diversity of topics, and we have a diversity of jurisdictions represented here from Halifax, Montreal, and Vancouver. And so this will be very interesting to hear from these panelists. So we're going to begin with the defense of due diligence by Rhonda Vanderhook.
Thanks. Let me just get myself positioned here. You could say I'm doing my due diligence to make sure that I don't end up banging into the mic. Hello, it's a pleasure to be asked to speak to you. It's a pleasure to be asked to speak about a topic that comes up regularly in the work that I do, and to have an opportunity to talk about due diligence and what it might look like. Before I start, an interesting story. When I was a defense counsel, a criminal defense counsel, I remember telling a judge who I was quite fond of that I was leaving the defense side and joining the Crown Attorney's office. And he said to me, "Come into my office, I want to have a little chat with you before you do that." And I said, "Okay," so I did. And he said, "One of the things I noticed about you whenever you present an argument to me is that I always know when you're not quite convinced because you start to speak very quickly. So when you go to the Crown's office, try to make sure that when you're presenting your case that you do it slowly, and hopefully you'll be convinced of the merits of your case." I thought about that advice years later as I gained more experience doing regulatory prosecutions, because I quickly realized that the provincial court is the forum, but more often than not, judges are not hearing regulatory trials on a regular basis. So oftentimes I would appear in front of judges who had never heard a regulatory trial. And it really benefited the prosecution to present the case in a nice, slow, careful way so that the court had an opportunity to understand the environment that we were in the particular regulatory trial that we were involved in. But secondly, I noticed that defense counsel were also in the habit of doing what I had been in the habit of doing, which is to race through the due diligence aspect of the trial, almost as a way to confuse and then get the result at the end of the day that they wanted, which was acquitted because I found due diligence. And of course, that would then lead to the inevitable discussion about whether we should appeal and a bit of reflection on how we could have approached a trial differently, such that the due diligence would have been more carefully analyzed, more carefully considered, and we could have ended up with a very different result. So that judge who he's now retired, I'm very fond of, I am very pleased with the advice that he gave because it has informed the way I and my team approach prosecutions in the regulatory context. First of all, just a little bit about me, and I should say that just like my colleague Martin said the other day, any views that I express, I'm told to come with the caveat that I'm speaking personally and not for the Public Prosecution Service of Canada. That said, I have noticed since I've become a regulatory prosecutor that there seems to be an ongoing interest in the public in environmental issues. I can remember a time, which doesn't seem very long ago, when it wouldn't be a big deal to see someone pour their paint thinner down the drain in the street or whatever. But now, more and more, people in everyday life are starting to stop and think about the implications of the decisions that they make. Whether it's hand soap that contains antimicrobial properties and how that might affect the well that will eventually wash into, people are much more interested in these issues. And as a result, lawyers are much more interested in these issues. And that means that lawyers are carefully considering things such as due diligence when it comes to advising their clients on how they should approach their business operations. And more often than not, while we do obviously have the hunter who shoots a migratory bird, more often than not, a lot of these regulatory offenses involving the environment relate to businesses. Mostly profit tends to be something that is driving a lot of environmental offenses, at least the ones that I deal with. To that end, I've noticed that there are more conferences available where lawyers are learning how to advise their clients on due diligence, what to consider. And recently we had one in Nova Scotia, which was put on by Defence Counsel to talk to different Environment Canada was involved too, to talk to different businesses, for example, the power company, about how they might consider the work that they do. So I'm pleased to be able to talk a bit about due diligence because I know that it's an issue that everybody is interested in. But one of the takeaways I'd like to say about due diligence is that when a due diligence defense is done well, when the evidence is solid, when you can take something away from the due diligence, an important thing happens. A message is sent to the community. What will represent due diligence in a particular industry, in a particular environment? And I know one of the earlier presenters alluded to this as well. You learn something and you take something back. And hopefully these types of offenses won't happen so often because people will have learned what will constitute due diligence, and they will engage in practices that will lead to due diligence. Now, in my paper, I set out a bit of the history of due diligence, and the defense generally arises in regulatory prosecutions, as I've said. And the case law is filled with good examples, although sometimes difficult to find, and sometimes cases are not reported, so we don't always have the goal achieved of a message being sent to the community of what exactly will constitute due diligence, because often the decisions are at the provincial court level and they're not often appealed, so they may not go any further than that. One of the reasons we have difficulty sometimes with appeals, and lawyers in the audience will certainly appreciate this, is that in different jurisdictions, due diligence is a finding of fact, and sometimes it's not. Sometimes it's considered a legal issue, and that means we have different burdens when we appeal. So we have to be aware of that. Now, the speaker just previous to me talked a bit about, the speakers talked about the history of Sault Ste. Marie and how that case set out a difference between, or set out absolute liability offenses, strict liability offenses, and distinguished them from mens rea. But the most important paragraph from my perspective from that case, in speaking of due diligence, is when the court says that offenses in which there is no necessity for the prosecution to prove the existence of mens rea, the doing of the prohibited act prima facie imports the offense. That's my first step. Leaving it open to the accused to avoid liability by proving that he took all reasonable care. This involves consideration of what a reasonable man would have done in the circumstances. The defense will be, and I'm continuing to quote, the defense will be available if the accused reasonably believed in a mistaken set of facts which, if true, would render the act or omission innocent, or if he took all reasonable steps to avoid the particular event. These offenses may properly be called offenses of strict liability. So what are the aspects and the essential elements of this offense? The case law has been evolving, obviously, since 1978, when this Supreme Court of Canada decision came down. And we've gotten closer to what is the reasonable man, what might constitute reasonable steps, and lots of courts have provided guidance on how this issue should be analyzed. But the starting point, and the most important point, is that the onus is on the defendant to establish due diligence. It's not on the Crown. The Crown need simply prove that the act has occurred, and then the burden shifts. And the onus is on the defendant on the balance of probabilities. Now, a frequent source of trouble in the regulatory trial is a failure by either the court or by the defendant to appreciate where that the burden is firmly on the defendant. Sometimes, as Alex Akajani alluded to on the first day, sometimes if the Crown has enough information to provide the court to suggest there is no due diligence in this case, it's helpful to the Crown to do that. And we will do that in cases where that happens, but it doesn't always happen. But the burden, like I said, is on the defendant. But what will happen often in cases is that defense counsel will call no evidence, but try to persuade the court just on the basis of closing submissions without any factual support that their client was diligent. And sometimes courts will accept that, and that's an error because there has to be a foundation for a finding of due diligence. Other arguments I've heard in trials and have been reported in some of the case law are simple suggestions that, well, the law is a bit too tough. The conditions in my license were too confusing. I don't really understand what I was supposed to do. Just look at this 50-page license condition that I have. How is a normal person supposed to understand that? And then without going any further to consider what is required of due diligence, there could be a finding that, yeah, a little tough. So acquitted on the basis of due diligence. But the law is clear that the person has to prove due diligence. There was a case that I mentioned in my paper, which gives another example of what can go wrong when this basic onus and the balance of probabilities test is shifted or created into, or turned into something a little different. In a case called Kehoe in Newfoundland, in the Newfoundland and Labrador Supreme Court addressed both the onus and the standard of proof in overturning an acquittal. Now, this case was very interesting, and what I wanted to do is, instead of just giving you basic cases, I wanted to give you a few different cases to think about. And I like this one, because in this case, what the court did, the trial judge did, is applied the WD test to due diligence, which is interesting, but more than likely encouraged by the defense counsel. Now, before talking about what the Supreme Court in Newfoundland ultimately said, because I appreciate that the audience is varied here, the decision in WD is a Supreme Court of Canada decision. Here's what it basically tells a judge to do. 1, first, if you believe the evidence of the accused, obviously you must acquit. Secondly, if you do not believe the testimony of the accused, but are left in a reasonable doubt by it, you must acquit. Thirdly, even if you are not left in doubt by the evidence of the accused, you must ask yourself whether, on the basis of the evidence which you do accept, you were convinced beyond a reasonable doubt by that evidence of the guilt of the accused. So what happened in Kehoe is the judge was invited to, and did, apply the WD test to due diligence. But as I've just indicated to you, due diligence, the onus is on the defendant to prove it on a balance of probabilities. The Supreme Court in Newfoundland said, and I quote in my paper from them, the trial judge achieved the wrong result by mistakenly applying the WD test to the defense of due diligence. His approach to the evidence effectively relieved Mr. Kehoe of his onus of proving on a balance of probabilities that he had exercised due diligence to avoid committing the offenses. The court went on to say, the trial judge was right when he said that applying the WD test becomes a little bit complicated when you get into regulatory offenses. Breaking the trial into 2 phases with shifting and differing onuses of proof is what complicates the procedure. The WD test did not fit into this case at all, and the court points out that obviously you apply that at the actus reus stage. If the trial judge had ignored the WD test and assessed the evidence about due diligence on a balance of probabilities, it would have been patently obvious to him that Mr. Kehoe had not met his burden of proof. Then the trial judge would have reached a different verdict. An interesting case because it's the kind of thing that once these things happen once, I find they tend to happen again. So even though the Supreme Court in Newfoundland basically said, no, that wasn't a good approach, it doesn't mean that creative counsel across the country won't try to do it again in another case. So it's just, it's good to be familiar with what's going on out there. What else does due diligence require? To meet the onus, a defendant is not required to prove that he took all possible or imaginable steps to avoid commission of the offense. Nor is he held to a standard of perfection, requiring superhuman effort. But he must prove that he had a proper system in place and that he took reasonable steps to ensure the effective operation of the system. And then he'll be assessed against the standard of a reasonable person in those circumstances. Sometimes courts are helpful to us in giving us a list of things that we might want to look at when it comes to assessing such things. There was a case called, it's an older case, 1992, Commander Business Furniture Incorporated, which is in my paper. That court set out a list of things to be considered. And since every case is factually different, the court will ask, when discussing a reasonable person, a court will ask about the reasonable person in the particular circumstances and what that person would have done. So what we read into that is the reasonable fisher, the reasonable pulp and paper company, the reasonable operator of a landfill, fill in the blanks and put yourself into the factual situation that you find yourself in the trial. What would the reasonable person in that context do? What would they have done to avoid the commission of the offense? So some of the factors that were listed in Commander Business Furniture, and I'll just comment on some of them as they relate to cases that my team and I have been involved in. One of them is that the court will look at the nature and gravity of the adverse effect of what happened, the foreseeability of the effect, and the court in that case says including abnormal sensitivities. The foreseeability of the effect. A lot of the cases we deal with in the Maritimes involve habitat offenses where property owners, for whatever reason, will decide my property abuts a river. It's very inconvenient to me that this river may flood the banks sometimes, and it doesn't look very good. So I will rock it up, bring my excavator in, and I'll put lots of rocks in the river, and that way the end of my property looks much more distinct and beautiful. But meanwhile, the river floods every spring, and this river has an intensity of force as it goes through the countryside. It's foreseeable that property owners down the river are going to be impacted by this, because once you take away part of the route of a river, it has to adapt and create a new route somewhere else. So we've had cases where other property owners are affected by the actions, the incursions into the habitat by a certain property owner, and it's very easy to argue that the reasonable property owner should know that when they rock the river bank on the edge of their property, that there is a foreseeable effect further downstream. Other factors are what were the alternative solutions available to the person in the circumstances. What is the legislative or regulatory, what is required for legislative or regulatory compliance? Important, because the reasonable person looks to see what is the legislation that connects to the actions that I'm engaging in. Am I subject to any regulation? Is there anybody I should be talking to before I engage in certain activities? For example, if you own property on the ocean and you've decided that you'd like to put in a wharf, or you'd like to put in a huge stone berm, that most likely will have some interest to the Department of Fisheries and Oceans, and not only to your province, but also to the Federal Department of Fisheries and Oceans. So the reasonable person will find out before they put things into the ocean what regulatory environment they might be stepping into. Another helpful consideration from the Commander case, what are the industry standards? In prosecuting the Irving Pulp and Paper Limited, for example, it was very helpful to the Crown, to us, to hear, to find materials during our searches, for example, of what the industry standards are in the pulp and paper mill, pulp and paper industry. If you read those and you see what other pulp companies are doing, then that's helpful to the Crown, because it's helpful because I now know what they knew about what the industry standards were and what they should be considering in the work that they do. So these things are helpful because they put us in a position where we can defend against a suggestion of due diligence. Some of the other ones, let's see. What efforts have been made to address the problem, over what period of time, and the promptness of their response. I was when one of the earlier speakers was mentioning the building that looked into changing the glass windows. I was thinking back to this commander case, and I was thinking it is important for them to engage in some work to deal with the problem, because ultimately it'll help them. It may not help them with a due diligence defense, but it's certainly worth considering, because it'll go to sentencing, and it shows that they're they're being proactive to deal with these things. I wouldn't want to see that turn out to represent due diligence, of course, but you can see the danger in that it could. So a Crown has to be very careful to make sure that factors such as these are still being assessed in the context of the due diligence law. Some of the other things to consider: matters beyond the control of the accused, including technological limitations. I had a case in Prince Edward Island where a number of fishers, were putting traps on the line, which is an imaginative line, in the water that divides the open area and the closed area. Benefit, of course, is that nobody's allowed to fish in the closed area, so the fishing there would be quite good. So putting your traps on the line has an economic advantage. But what they tried to do at trial was to basically argue that, well, the GPS, could have been broken. Maybe it wasn't working. There could be satellite issues. Because did you know that every now and again, all of those satellites up there, sometimes they all get out of alignment at certain times, and therefore the results won't be accurate. And maybe we were diligent and our equipment worked, and so went the argument. But at the end of the day, we called expert evidence to basically shut that down and to show how that was practically impossible for that to have happened in this case. But it's interesting, because if the judge had thought, well, I suppose that's possible, that there's a technological limitation to the gear, that it's reasonable to rely upon a GPS, then they could have established due diligence. So in that case, and I'll talk a bit more about this, it's incumbent on the Crown to try to figure out what might be coming and see what you can do to put a stop to the suggestions. Other factors are the skill level expected of the accused. For example, an experienced lobster fisherman who has been a captain for 20 years, trains his crew, tells them how to measure. Can he rely on the fact that he's trained them and he's been carefully watching their activities? Yes. Because he has the experience to teach, he has the experience to ensure that they're doing a good job. So if there's a one-off where they are found not to have measured correctly, is it fair for the captain to be found guilty? Not really, because he was duly diligent. He has to have a crew, and he has to train the crew. So we have seen cases where that has happened. And we have to push for it. We have to really find out what the facts are. But you can understand why a due diligence finding might happen in that case. But of course, we would emphasize that we need to see what the system was in place and how they were employing the system. So there are other steps. So don't take that as a blanket statement that will always happen, in case there's any fishers out there watching from home. Other factors include the complexities involved in what they're doing, what preventative systems are there. So therefore, we would be looking at seeing some evidence from the defense on training. What kind of training is happening? Let's evaluate this training. Let's see if this training is effective. Does it make sense that you're using this type of training to avoid the commission of this particular offense? We want to look closely at those things when we're looking at due diligence. I think those are the sort of the highlights from that case, and helpful, and also other cases will give us some things to look for. Now, it's interesting, because I talked about the fact that we'll look at the reasonable man, and the reasonable man will be the reasonable, and I'll say man, although I could just as easily say person or woman. We'll look at the reasonable person in the circumstances. Fortunately for us in the Atlantic, where we have a lot of fisheries prosecutions, the reasonable man, we look at the reasonable fisher, but we also have gotten to the point where we're looking at the reasonable fisher in a particular fishing industry, in a particular type of fishery. And I mention cases in my brief, such as Gould, a Newfoundland case. A lot of these fishing cases seem to come from Newfoundland. And that's actually one that I was alluding to when I talked about an experienced lobster fisher being able to rely on the actions of his crew that he had trained. That's Gould, 1995, Newfoundland Supreme Court decision. And likewise, that sort of brings us to the second prong of the due diligence defense, which is if the accused reasonably believed in a mistaken set of facts, which if true, would render the act or omission innocent. And the court will look at the facts, and they will consider whether the defendant could reasonably believe certain facts. So a case that I mentioned, a Nova Scotia case from the Nova Scotia Court of Appeal, Harris, in my paper, that was the case where the judge decided that the captain in that case, it was reasonable for him to rely. This is another. Actually, I should apologize. Gould was actually a case that dealt with whether he should have relied on the measure that DFO had was using to measure short lobsters. Harris is actually the case that I meant to mention that deals with the captain. In that case, the judge decided that it was reasonable of the captain to believe that the crew had been trained such that they would do their job properly. Sorry for the confusion on that. However, reasonable actions must relate to the offense charged and not some broader version of acting reasonably. That's another point where we often get into difficulties in regulatory prosecutions. And I know Alex Ikajani mentioned it yesterday when he talked about a case, I think it was Williams, I believe it was called. Sometimes what courts will do is they'll look at a fact situation, and instead of applying due diligence and reasonable actions to the offense, they'll look at the person. He seems like a nice guy. He seems like he's hardworking. I don't think he meant it. It doesn't matter if he meant it. It doesn't matter if he's a nice guy. It doesn't matter if he did a lot of reasonable things after the commission of the offense. It's hard to, sometimes you want to say it when you're in a trial, but you can say it here. Those are factors that we can look at on sentencing, but they're not factors to be looked at in assessing whether or not the Crown's proved its case and whether or not due diligence has been established. It's been my experience that most of the people I prosecute, when I walk out of court, they shake my hand and say, see you later, and take care, and hopefully we won't see you again. A lot of them are very nice people, but that's not what we're here for. Regulatory offenses tend to be about money. They tend to be about making money. They tend to be about getting around a rule, and they're not usually committed by people who are inherently evil. And therein lies one of the problems when you end up in provincial court with these prosecutions, is that judges are used to seeing assaulters, sexual assaulters, bank robbers, break and enter, these types of things. So when you run into a nice guy who is, happens to be, he owns a nice piece of property and he wants to put a bunch of rocks into the lake. Or in a case I had, a very wealthy man who was a great benefactor to the community, decided his lake house needed to have a few brick walls built into the lake because he wanted to make it look prettier. But of course that meant that whenever this lake, the waters would rise, this would flood out other people's properties and cause siltation and lots of problems for the community. And he made lots of donations to charity just before the trial and that type of thing. But it doesn't take away from the fact that this is a strict liability offense. Nice people commit strict liability offenses all the time. Let's look at that on sentencing. But for the purposes of the trial, let's look at what happened, and let's look at what actions this person took to be duly diligent to avoid the commission of the offense that we're here dealing with. So when a court doesn't do that, or do what they should do there on that topic, and they start to look at broader notions of reasonableness, we end up in a case where there's a case I mentioned in my paper called Boyd that we ended up having to appeal to the Supreme Court in Nova Scotia, and ended up with the result that we wanted with respect to due diligence. But that case is interesting because we had a fisher, Boyd, who went off to set crab traps, put them near the line. And I think it's fair to say that most fishers who drop their traps near the line are not that concerned about where those traps are going to end up. They're just concerned about whether they can happen to get access to the area where nobody else is fishing. So the traps are dropped and he leaves. So the next day he comes back and finds the traps in the closed area where logically they were going to end up, and calls DFO. The traps are over the line, they're in the closed area. He does a lot of admirable things after that. What do I do? Da, 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 da. But it doesn't take away the fact that he committed the offense. So what happened at the trial is that the trial judge looked at the evidence and said, well, there's no doubt that he was fishing in the closed area on May the 2nd. he didn't do anything to avoid it. But the judge then went on to consider the reasonable actions that he had taken the next day, and decided that because his actions the next day were admirable, that somehow translated to due diligence. And on that basis, he was acquitted. So we appealed, and in overturning the acquittal, the Nova Scotia Supreme Court said, as noted in Alexander, also a common case that we mention in these due diligence cases, the due diligence defense must relate to the external elements of the specific offense that is charged. In this instance, the trial judge, when considering the charge related to May 2nd, properly found that the respondent was not diligent. The inquiry should have ended at that point. To extend the examination of the respondent's actions beyond the date of the offense was, as described by the court in Kurtzman, improperly considering some broader notion of acting reasonably. The Crown must guard against that happening, and perhaps even mention that being a nice guy should be considered on sentencing, respectfully. There's another interesting way to figure out how to figure out what is due diligence. And while we know that we look at the case law to determine what may constitute due diligence, sometimes the legislation is helpful. And sometimes the legislation surprises us by being useful, as it did for my team when we dealt with a case in the Atlantic called, well, first we had one called NERI, and then we had another one, which it was basically NERI Take Two, which is called Arbuckle, which was just decided in 2013 in the Nova Scotia Supreme Court. Basically, this one, it bears a little description, because while not, like I said, I want to give you some examples of things that might not be too common, but they'll turn your mind to thinking about things in a little bit of a different way. One of our Crown agents prosecuted this case, and what had been the practice is in this particular fishery, and let's see, was it herring in that case? Yes, it's herring in that case. The Atlantic fishery regulations talk about 3 or 4 different species of fish, and they set out a regime where you are not allowed to have any of the certain species if they're, we'll just say short, I won't get into the measurement. You're not allowed to have short herring, period. But in that section that lays out the offense, it goes on to tell you, you can have it if you meet some conditions. One, that catching that short fish happened incidentally to directing for longer fish, and the amount that you have represents less than 10% of your catch, your total catch. And then it sets out a method for determining what would represent 10%. And I'll just read that part. The percentage shall be determined on the basis of 4 or more samples taken from the catch, with each sample containing 50 or more herring. So it's pretty clear what has to be done here. But what wasn't clear is, in the industry, what was happening is fishery officers were inspecting catches and engaging this sampling method. So they would go and they would take 4 or more samples of the catch of 50 fish and measure them and determine, for their satisfaction, whether these people had exceeded the 10%. So this is what DFO was doing. So at our trials, what we were doing is we were leading evidence of, the boat came in, we saw short herring, the fishery officers engaged in the test, that's set out in the legislation, determined that 50% of the catch was short, conviction. Well, what happened in NERI and in Arbuckle is the defense counsel said, let's look at how the DFO officers did their sampling. Was it truly random? Which, as you heard, I did not read in that section of the legislation. And let's look at how they did the testing. Was it truly random? Was it representative? Should they have taken 5 or 6 more samples? Were they sampling from the same bucket twice? They were getting into a lot of this analysis. So what happens is the court then reads in that the sampling is part of the offense, that we have to prove that DFO sampled correctly. So we didn't share that opinion. We went to appeal NERI and then Arbuckle, and basically the Supreme Court in Nova Scotia said the sampling method is not an element of the offense. All the Crown needs to prove is that there were short fish. Due diligence is actually being codified here. It's up to the fisher to show that the sampling was done and that they looked to see whether they had more than 10%. It's not up to DFO. It's a useful tool for us to figure it out, but just finding short ones is enough for us. And it was interesting simply because we'd never looked at it that way before. We never thought that legislation could mean that, which was interesting. A lot of prosecutors had just, it's not a section that comes up often, but it was something that we had just never really considered. And it led me to think that it's very important when you're putting these cases forward to really look carefully at your legislation to see whether or not there's an opportunity for due diligence to be set out for you. It's set out in that example. It's also set out often in license conditions. It's set out in the authorizations that people get to do the work they do. It's often set out by industry standards, as I mentioned before, say, for example, in the pulp and paper industry. We have to, as Crowns, look to find that type of information, and we need to rely on our investigators to help us find that. But importantly, we have to put that before the court, because it's not fair to critique the court unless the Crown is in a position to put the evidence forward to assist the court in determining what is due diligence. So my takeaway from that particular case is that, and I would have thought after the first decision that the message would be out in the community that the fishers now have to start doing this sampling themselves, but I was wrong, because then Arbuckle happened and we had to do the whole thing over again. These cases are important for general deterrence because, like I said earlier, due diligence, when well established and well argued, sends the message out to the people who are engaged in the industry. This is what you're supposed to do. So now, hopefully in our area, fishers are not relying on a challenge the way DFO tested. Instead, they're going to test themselves, and they're going to put a system in place in their fishing operation so that they can show that they have been doing this testing consistently throughout their trips. So basically, the message of general deterrence comes through in the way you do the case, as well as in the decision in the case, as well as in sentencing. I don't know how much more time I have, but one of the cases that, just a few, I just want to ask you all to consider reading the Gemtech decision. This is an important case in the environmental field. My colleague Paul Adams, who is an exceptional prosecutor, prosecuted this case. Long time. It was a case involving the city of Moncton, and I'm just going to try to do it as quickly as I can. The city of Moncton wants to shut down their landfill site. It's an old-style landfill site. There's a lot of leachate running out of this property, running into the rivers, and basically polluting the environment in the city. So they engaged Gemtech to come up with plans for how they might remediate the area. Gemtech comes up with two options, one less expensive, one quite a bit more expensive. The city adopts the first plan, which will still see leachate running off the property and into the river system. So what ends up happening is that plan's adopted, and the city begins to implement the plan using Gemtech to implement it and to put in place to hire contractors and basically to do all the work. Now, somewhere along the line, because this was a public process type thing, a scientist came on board, Lapierre, and said, this plan doesn't consider the Fisheries Act. It doesn't consider the impact on fisheries on the waters. But that was ignored. And ultimately, the plan was implemented, and a new pipe was put in under the direction of Gemtech to divert more leachate in a more direct way, which was very actively engaging in the actual releasing the deleterious substance into the water. Now, in the past, according to my colleague Paul Adams, it was high near impossible to prosecute a consulting company involved in making recommendations and engaging in some implementation. But that all changed with this case. And this is sort of like a feather in the cap of Environment Canada. Not surprisingly, the consultant tried to argue that they were diligent because they were trying to follow direction from the city as to what they wanted. The province had been engaged with respect to what they wanted done, and they also had to take into consideration financial implications for the plan and how it would be implemented and the like. So really, they weren't really responsible. They were just consultants. But the court didn't see it that way. The court rejected all of their attempts at due diligence. And the reason I say read this case is because it has a lot of, it really talks about examples of, ways that you think, oh, I suppose that could have constituted due diligence. But in a case that was so thoroughly prepared and researched, where the background to this type of operation was so well known by our Crown. He was practically an expert in landfill leachate by the time he was finished, working with the Environment Canada officers. He was able to really carefully dissect the due diligence argument and refute that there was any due diligence here. And the court agreed with him. And ultimately, this prosecution ultimately sends a very strong message across Canada to consultants that they have to be very careful and duly diligent in the work that they'll carry out when it has implications for the Fisheries Act. That's a sort of encapsulated version of what that case is about. So just to sum up, my takeaway on the due diligence is take it slowly, take your case slowly, and prepare it clearly. But take a nice, slow, careful approach to due diligence, dissect it, make sure that the burdens are in the right place, that you've looked specifically at the environment that you're working in, become knowledgeable on it, and be able to dissect due diligence because you have the background to do that. And above all else, make sure that you, while risking potentially insulting a court by giving too much information on the basics of due diligence, you have to do it. Because the reality is there are lots of judges who don't deal with this on a regular basis, and they appreciate it. And, I actually had this happen. I won't name the judge, but a judge who had been practicing or been sitting on the bench for over 10 years said to me when we were setting down a fisheries trial, said, I'm going to be frank with you, I've never ever done a fisheries trial before. I've never done a regulatory trial. So if you wouldn't mind putting together a brief to put me where I need to be on strict liability and any defenses I need to consider, I would appreciate it. And even after the change in plea, now would you mind giving me case law so I can understand the difference between, in this case, mandatory and permissive forfeiture under the Fisheries Act? And it was nice to be invited to do it. And counsel can be so helpful to the court when we do that, but know that sometimes we're hesitant because we don't want to insult the court. We don't want to suggest that maybe the court doesn't understand it. But I think in a lot of cases that type of thing would be very helpful, and I think that counsel could benefit from doing that, and the case law will benefit from doing that, because then we won't end up with decisions like the WD applied in the context of due diligence and some of the other decisions that I gave you as examples. Thank you.
Thank you so much, Rhonda. That was fascinating. Lots of varied issues and very interesting examples. So we have a couple of minutes for questions from the floor, if we have any. Ready?
Oh, and I should say, I'm not afraid of private prosecutions.
Thank you. Here's a question for you. You note that many lower court decisions on due diligence get overturned on appeal. Where do lower courts tend to go wrong, and why, other than perhaps a tendency to sympathize with a particular defendant?
Well, that seems to be the main problem that we run into. But like I said, it's sometimes it's just not really laying out what due diligence is and looking more to be fair to a nice person. It's ultimately where I see things going awry, because we often read the decisions and we think, wow, I don't understand how the court could not have applied the law. And then you look a little bit carefully and you think, well, he was a pretty sympathetic defendant. And that's where you run into the problems, generally speaking. So, I try to always say to the court, these are all of these offenses, generally speaking, are motivated by money. We're not, we don't have nice guys and bad guys. We just have people getting around rules and people who are trying to make money that they're otherwise not entitled to. Now let's apply the law.
The next question is, are you seeing any mistake of fact defenses in your prosecutions in lieu of the due diligence defense?
No, I'm not. Simple answer. And I'll leave mistake of fact to the next speaker, I believe, was talking about that. I'm not, personally, no.
Great. On appeal and due diligence, is this a question of law or fact?
Well, it depends on the court or the province that you're in, quite frankly. And I'm mostly familiar with the Atlantic, of course. And it's interesting because depending on which province you're in, we'll look at our cases for review and we'll say, well, you know, it's really hard to argue that the judge got the facts wrong here because the judge is accepting the facts and he gets to decide what the facts are. So we've had appeals that, you know, we've run them and then we thought, oh, we shouldn't have bothered. But then, you know, where we can get into a connection with the law, we're a little bit, generally speaking, better off.
Okay. And the last one
We'd love it to be consistent, but it's not. So.
In the due diligence defense, is the due diligence defense now settled law in most respects after 35 years? Or are there still areas of ambiguity or where you would see potential for evolution?
That's an interesting question. I think sometimes the way the law evolves isn't, things happen and you think, that makes sense. Why didn't we think to argue to help persuade, to change the law on a certain aspect? I can't think of anything off the top of my head. I would prefer due diligence to always be a finding of law, or you know, an application of the law rather than an emphasis on the facts. But whether we'll head to that eventually, I don't know. But I do think that because due diligence is so specific to the industries that we're dealing with and the fact situations, as long as courts are always carefully considering all of those details in the factual environment that we're in, then I think that there's a very strong potential for always applying it properly. But that said, and I don't think I said this in my presentation, but I perhaps said it in my paper, it's also important for the Crown to find out what will constitute due diligence. I say to the investigators that I deal with, great, I want to know about the facts of the offense, but I also want you to find out what due diligence would have looked like here. Talk to people. I don't want to hear somebody come to court and tell me their due diligence defense when they could have told you. Or you could have done some background looking to find out. Because if there is due diligence, I don't want to prosecute. I mean, it can happen that people are duly diligent. I can accept that. But I need to know it. I need to know it in the investigation that's conducted. So that's one of the things that I spend a lot of time with investigators in investigative training. I say, you know, sure, it looks open and shut, but please give the people an opportunity to give a statement. Because that statement may be very helpful to me later on down the line. And it may be helpful because the excuse that they give at the time may turn out not to be the excuse that they want to give later on at trial. I'd like to be able to have a chance to look at both and, you know, persuade the judge of whether or not diligence was proven or not.
Okay, I'm just going to add one of my own questions. So I presumably where it's a question of fact, the science would play a larger role, and where it's a question of law, the science would be less important, or is that not necessarily true?
Oh.
And the other question is, do you see a lot of scientific uncertainty, and does the precautionary principle play a role to date in your experience?
Perhaps what I'll say is that I think science is very important for due diligence. I'm trying to think if I can think of any cases recently where there's been an issue on that. I can't think of anything that readily comes to mind, and I may be confusing this situation, but I recall a case that my colleague Denis Lavoie and I did quite a long time ago, where there was a lot of overfishing happening in an area where for lobster. Our scientists from DFO testified, of course, that, I say of course because it seems to go without saying, that you can't continue to fish a resource to the point where, without it being regulated and watched and conservation principles being applied, and expect the resource will be there for you know, tomorrow. The defense surprisingly called an expert witness, a scientist who was qualified, who testified that there is no impact on lobster stocks by fishing without regulation, and that fishing could go on continuously, and there would never be an impact on the species because it's so well established that you could never deplete the resource. I still marvel at the fact that the scientist was qualified, but in any event, that was interesting to me because, well, I don't know if that gets to your question, but that's the only situation I can sort of think of where due diligence came in with the science, and then of course the judge, thankfully, said, I can't accept that. I just can't accept that position as being accurate. It doesn't make any sense to me, and I'm prepared to accept all of the evidence of the Crown scientists with respect to this. And that's how that case that was a determining point in that case, I'd say.
Thank you. Thank you very much.
Thank you.
So we're